So awesome. All right. I am so thrilled to welcome someone who is absolutely changing lives, freeing lives, literally. Tricia Bushnell. She joined the Midwest Innocence Project in December of 2013. She got her Juris Doctor from New York University School of Law, where she was also an Arthur Garfield Hayes Civil Rights and Civil Liberties Fellow. She currently serves as on the executive committee for the Innocence Network and as the president of the ACLU of Missouri. Let's welcome Tricia Bushnell.
Hey folks, hopefully this works. I apologize, I feel a little bit like Star Trek wearing this, but I'm a hand talker, so you'll see that soon. So thank you all for having me here today. I want to talk to you a little bit about some of the work and the experiences and lessons I've learned doing innocence work as an attorney and how I got into that work, because I think there's a lot of things we don't know about the criminal justice system until we get our hands in them and experience them. The two caveats I always give when I give a talk is, one, I grew up in California, so I talk really fast. If for some reason I'm going too fast, you want an explanation of something, please raise your hand. The second thing is I used to be a law professor, as you may have heard, which means I can talk a lot, right? So I'm going to do the best that I can and the time that we have today to really talk about why do wrongful convictions happen, all right? So the first thing I just want to start with is an overview of what my organization is with the Midwest Innocence Project. We represent people who are convicted of crimes they did not commit. They must be actually innocent. We do not represent people who maybe have their constitutional rights violated, but actually committed the crime. That's what's called a wrongful conviction. We don't do that in our office. All right? Studies say that 2 to 5% of all people who are all people incarcerated are wrongfully convicted. So what does that mean for us? My nonprofit works in a 5-state radius. We work in Missouri, Kansas, Arkansas, Nebraska, and Iowa. So we're looking at somewhere around 5,000 people that may need our assistance. To put that in some context, I have 5 people in my office. So it is a really, really long wait list. In addition to that, it is a really, really long process to correct these injustices. So some of you may have heard of a client we just had who was released on October 13th, Lamont McIntyre out of Kansas City, Kansas. It took 23 years for Lamont to come home for a crime he did not commit that he went in for when he was just 17 years old. It took 8 years of investigation. Why does that happen? Right? So in our office, not only do we try to correct these injustices, we also try to create policy to prevent them on the front end. And so what we've done is when we look at the different causes of wrongful convictions, and for those of you who are in the back, I'll read you what you are, we know when we look at DNA exonerations and we look at just the convictions that have been overturned overall, what is causing them. And the main leading causes of wrongful convictions is perjury or a false accusation. So somebody lied, right? I think we can all believe that that's a leading cause. We also have mistaken witness identifications. What that means is somebody saw a crime and they picked out the wrong person, right? We know why that happens, or we know why we cognitively bias people to do that, and we have measures that we can prevent them to change that. It's called eyewitness identification reform. We've been able to pass that reform in Kansas, but in fact in Missouri, in the legislature, they will not. We've asked for 5 years to present it. They won't even have a hearing on our bill. And the reality is the measures that we take to change that cost $0. In fact, law enforcement joined us in Kansas to change it. But despite the fact that every single DNA exoneration in Missouri, that's 16 DNA exonerations, was the result of an eyewitness misidentification, we've done nothing to prevent that or change that here in Missouri. So these are the things that we work on. But you'll also see one of the leading causes, almost 50%, is official misconduct. What does that mean? That means prosecutors or judges or somebody who is part of the justice system, law enforcement, withheld evidence, hid evidence, manufactured evidence, created something. That's exactly what we see in Lamont McIntyre's case. For those of you who don't know his case, Lamont went to prison when he was 17-year-old for a murder he did not commit because a detective had been sexually abusing his mother. He was known for 35 years, this past 35 years, to have been sexually abusing poor, black, marginalized women in the Kansas City, Kansas community rampantly. He would abuse them and say things like, "I'll keep you out of jail if you'll give me a sexual favor." We've had more continuously calls coming in and more abuse that's happened. I had a woman on the phone who told me he would get my boyfriend out of jail. if I gave him a sexual favor. For 35 years that happened. He was abusing Lamont McIntyre's mother. She said no more. She had to change her address and her phone number and move to be away from him. Fast forward when there's a call about a murder that happens, and he gets a call from the drug dealer saying, I need you to take care of this. There was a hit that went out. He creates a lineup of just 5 people. And in this photo lineup, he puts in 3 of Rosie McIntyre's family members. So in that regard, he didn't care which McIntyre he got, but he got Lamont. And then the victim's family, it was a shooting in broad daylight, the victim's family sees the shooting happen, they go to the prosecutor and they say, this isn't the guy who did it. That's not Lamont McIntyre who did do this. And the prosecutor says to them, no, you're going to get on the stand and you're going to testify that it was him, or I'm taking away your children, or I'm charging you with contempt. And so this family, who has lost their loved one and has been victimized, is re-victimized and forced to get on the stand to testify against someone they know is innocent. And that's what happens. And even though she then recants her testimony, it takes 23 years for that to get fixed. That prosecutor is now a U.S. attorney in Kansas City. At the time of this trial, that prosecutor and the judge, just a few years prior, had been having a romantic relationship which they did not disclose. So the misconduct in this case is rampant. But what is important, and the reason I'm even bringing it up today, is it cannot be the only one. The detective, Roger Golubsky, was a detective on that force for 35 years. I can look in my files and I can find applications of at least 8 other people who are saying they are innocent and this is the detective who worked on their case. So what are we as a community going to do about it? And the first thing I would say, and I would just suggest, is know your prosecutor. Because our prosecutors are elected officials, they are our representatives, and they wield tremendous power. Not only does the prosecutor decide who gets charged, not only do they get to decide what deal that they may come up with, they wield legislative power. They go to the legislature and say, these are the rules that we should abide by. And the reality is prosecutors are immune. So if a prosecutor commits misconduct and someone gets out later and they sue saying, hey, there was all this misconduct, prosecutors have what's called absolute immunity. They cannot be held accountable for their actions as a prosecutor. So it is absolutely imperative that we know these representatives who we are electing and what they're doing. So the fastest thing I'm going to do for you today to really explain why this is happening is I'm going to give you the fastest criminal procedure class any of you have ever had in your life. I don't know if any of you are lawyers here or if you plan on being a lawyer, but this is what I'd like to talk about today. So the reason this takes so long, why it took 23 years for Lamont McIntyre, why it took 8 years of investigation to get him out, is because of how the criminal justice system works. So what we describe it, we talk about it in the 9 boxes. So the first 3 boxes that we have here are what's called your direct appeal. These are the things that most people are familiar with. So you go to box 1, this is your trial court. This is what you see on Law & Order, CSI, right? You have a right to an attorney, your attorney's standing with you, and hopefully your attorney is making tons of objections. Because what they're saying there is, this is unfair, this shouldn't come in, or this evidence should come in, but here's all these unfair things, Judge, and you need to make sure that this is right, okay? When a student always asks, what should I be objecting to? I just say everything, and just say all the amendments. And you'll find out why in a second. Because what happens here when our client loses, and I'm going to use the term man or him because the vast majority of our clients are men, when they lose this, Mr. Client then goes to the Court of Appeals and the state court. So here I've given the Missouri Supreme Court. And they still have an attorney. It might be the same attorney, it might be a different attorney. And this attorney can now only raise those issues this person jumped up and down about. So if for some reason your trial attorney didn't object to something that was unfair that came in, too bad, so sad, this guy can only raise what this person raised before them, right? So if your attorney didn't put in your evidence, your important evidence of an alibi perhaps, doesn't matter, this court's not going to hear it. They're only going to hear those issues that were preserved at trial, okay? So we lose in the trial court, we lose at the Court of Appeals. We can ask the U.S. Supreme Court, they rarely take cases, right? They take 1 to 2% of all cases that are asked of them, and that's the end of your direct appeal. Okay? That's what most people think of. And when they say they'll correct something on appeal, they're talking about what this person objected to. So what does that mean for clients like what we have when they have an inadequate public defender? So Missouri is now ranked 50th, not even 49th, 50th in funding for public defenders. Dead last across the country. And they are overworked. They have dockets of hundreds of clients. And what does that mean for you if you're the client waiting in jail and you need them to go investigate your case? So that takes me a little bit to this guy, Ricky Kidd. Ricky Kidd is one of our clients here in Kansas City, Missouri. Ricky Kidd was convicted of double homicide here. At the time of the crime, Ricky was in the Jacomo Sheriff's Department getting a gun permit. Pretty great alibi, right? Unfortunately, it wasn't adequately presented by his trial counsel, who didn't put it in front of the court, didn't present all that, and didn't present evidence of the real perpetrators, the people we know who committed the crime. So when they go through all this process, they say too bad, too sad. So what does that mean? Well, he gets another shot. He gets to do what's called a state post-conviction. And in that case, you go back to the trial court. The very court who has sentenced you, and in the cases of my death penalty clients, the very court who sentenced you to death. And you say to this court, Your Honor, I have new information. And if you had known this information, you would either find that my trial was unfair or that I am innocent and I should get a new trial. So what are those types of new information? Many of you have heard of things like DNA test results, right? Those are new, they weren't available at the time of trial. Maybe a witness has recanted, right? And they get released that way. Maybe it's the state misconduct. So in the case of Lamont McIntyre, we have to prove that the prosecutor did this misconduct, or the detective had done all these horrible things. That was withheld. The state didn't give that over. Or that they had identified another perpetrator, exculpatory evidence. They didn't present to you evidence that your client was innocent. The state is required to turn that over. That's new, right? You couldn't have known about this misconduct at that time because they were hiding it, right? And the other thing is what's called ineffective assistance of counsel. If this person did a terrible job, I can't know until I do the work. So in the case of Ricky Kidd, his alibi, the surveillance tape of when he was going to his sister's office, all of those things couldn't have been revealed until someone gets to actually do the work, right? Or we also look at what are called juror misconduct claims, where juries are making decisions based not on what the evidence is in front of them, but on different things. We've had juries who have performed their own experiments in the jury room. You're not allowed to do that. We have jurors who have prayed for guidance for the answer instead of relying on the evidence in front of them. So those are all new things. And we say, hey, trial court, if you'd known this, you'd fine for me. And sometimes they do. I have a case in Alabama. It was the very first case I ever worked on. I was a law student. I was over a decade ago now. He's still my client. But when we went back to this court, to the judge who had sentenced him to death, that judge said, not only did he find he had inadequate lawyering, not only did he find that the state had given misconduct, he found our client was actually innocent and ordered a new trial. Unfortunately, so that was at the Alabama trial court. In 2010, they ordered a new trial for him. They went up on appeal. The Alabama Court of Criminal Appeals said, we don't agree, and they reinstated his conviction. So that has now been that was 2013. It's what, now 2017, and we're still waiting on the Alabama Supreme Court to rule and make a decision on that case, just to get to the end of box 5. Meanwhile, Mr. Gisandano, as our client, is still on death row. So you're trying to get through all of these processes. But here's the kicker, and here's what people don't think about. To get from the end of box 2 and back into box 4, so to get the end of your direct appeal, and now to try and present all this new evidence, most states say you have somewhere between 30 and 120 days. That's a month, right? It's like a month, 4 months. Some states are longer, or in Nebraska you have 3 years. But now you no longer have a right to an attorney. You no longer have any resources. You have no investigator, and you are incarcerated. So what I want to ask you is, how do you then find the evidence and the surveillance footage and the evidence of your alibi and the evidence of who really committed it while you're incarcerated with no investigator, no attorney, and you've got about 3 months? You don't. That's what happens. So folks file and they present. Tragically, in the case of Ricky Kidd, he filed here and he presented all this evidence and said, my lawyer should have presented my alibi. My lawyer should have presented who really did it. He filed on his own. In Missouri, if you file on your own, they'll then appoint an attorney. So you then got a Missouri public defender, who even though he had 11 claims, dropped all of them, except for 3. And those claims did not include those ineffective assistance of counsel claims, the bad lawyering claims. So when it came here, they were like, we don't have these to hear, so he lost. So he goes forward, he goes through the rest of this on his own, and he loses. So then what happens? Well, now you get a chance to go to the federal court. In the federal court, you can only raise those claims that were already raised throughout here but now you're saying it's under the federal system. So in the case of Ricky Kidd, when they didn't raise those bad lawyering claims about his alibi, the federal court won't hear it anymore. So once you lose in this one of these boxes, you're barred forever from being able to raise it over here. So the other thing is, in 1996, Bill Clinton signed what's called the Anti-Terrorism and Effective Death Penalty Act, which gave you 1 year to get from the end of this box to the end of this box, 7, from 2 to 7. It's incredibly complicated stuff. They consider habeas laws with this law, they say it's as difficult as immigration and tax. And we're expecting people with very little education and very little resources to be able to navigate this on their own, and they don't. So the reality is, you get 1 shot. If you miss your shot and you're out of time, too bad, so sad, we're not going to let you in. If you had a shot, and now you're trying to do it again, too bad, so sad, we're not going to let you back in. You only get 1 try. So by the time someone gets to us, we've got a wait list of over 600 people right now, right? So you look at Lamont McIntyre, you say, it's 8 years of investigation. How do we get back into court? That's the real question. So, in the United States, innocence is not a claim to get you out of prison. You cannot say, here's all of the evidence that I didn't do it, let me out. That's not a claim. You have to have what's called a constitutional error. There has to be some infringement on your civil rights in order to get out. And I see puzzled looks, and you should be puzzled. This is the state of the law in the United States. So the U.S. Supreme Court has never found innocence is enough. And in fact, when Troy Davis was executed in Georgia about 5 years ago, Justice Scalia wrote, we have never held that you do not have a right to be executed if you are innocent. Because we don't have that right. So what do we have a right to? Well, here in Missouri, we have a lawyer named Sean O'Brien. He teaches at UMKC School of Law. He's been doing death penalty and innocence work for a very long time. And he represented a man named Lloyd Schlup, who was convicted and on death row here in Missouri. And Mr. Schlup was innocent. So Mr. Schlup, like the rest of these cases, had gone through and there was nothing left. All of his lawyers had somehow messed up things where he couldn't get back in court to present his evidence of his innocence, and he had no constitutional claim. So in Lloyd Schlup's case, what the court said was, well, we haven't decided if innocence is enough for you to get out. But what we will say is, if you can show that you are actually innocent, we'll let you back into court. And that's what I have to do. In order to get my client into court, I've already proven they are innocent, and then I have to prove what the constitutional errors were that kept them from getting justice. Okay? So it's a very, very long, expensive process that people cannot navigate on their own. Some can, right? Especially when it comes to DNA testing, but it's expensive and time-consuming. So that happened, and then Sean litigated another case of a man named Joe Amrine, who was also sentenced to death here in Missouri. Joe Amrine was also innocent. He was convicted based on the snitch testimony, right, incentivized informant testimony, of 5 other individuals in the prison that say they killed another inmate. Well, fast forward a year later, one of those people recants. Joe files in court. And they say, yeah, that's great, but you've got 4 more people saying you did it, right? That doesn't mean you're innocent. So fast forward another year, another person recants. He tries to get back in court, and they're like, you already had your shot. You don't get to get back in court. Fast forward another year, right? And it keeps happening until now there's nothing left. Nobody says he did it. In fact, he was convicted to hide a prostitution ring that was happening in this prison, where the warden and other inmates were selling young inmates who were coming into the prison to other inmates. And when Joe went to file his civil claim after he was exonerated, the FBI agents were walking up the door to arrest the investigators and folks who had been part of this ring, and he took a pistol and shot himself in the head. Much like Shawshank Redemption is exactly what happened to Joe Amrine. And that went his civil claim for liability. So they go back to court and they say, Missouri court, there is nothing left to convict Joe Amrine. What are you going to do? And the Missouri Supreme Court, for the first time, said, there's nothing. You couldn't even arrest him, so we're going to let him out. And we thought, yes, finally, Missouri is going to recognize innocence is enough. If you can prove you're innocent, you can get out of prison. Except, fast forward now to 2016 for our client, Rodney Lincoln. So, Rodney Lincoln has served 35 years now for a crime he didn't commit. To put that in some perspective, Rodney went into prison the month before I was born.
So literally everything I have done in my life, Rodney has been waiting for justice. As I went to school, as I went to college, when I got married, law school, everything, Mr. Lincoln has been waiting. Mr. Lincoln was convicted of an absolutely horrible crime that took place in St. Louis. It was a brutal murder of a mother and assault on her 2 children. They were 4 and 7. It was amazing that the children survived. When they get to the hospital, the 7-year-old, they ask her who did it, and she says, Bill. Bill came from Los Angeles, Bill had long hair, Bill drives a white Volkswagen, Bill, 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 Bill. They show her dozens of pictures of men named Bill. She's never able to identify any of them. So then she says, well, Bill kind of looks like my cousin, so they take cousin, and from the cousin they make a composite. And then her relatives are looking at this now composite of cousin, and say, well, that kind of looks like a guy that the mother used to date, so they go through the mother's diary and they get Rodney's name. And Rodney had dated her about 9 months prior, and she'd only written lovely things about him in her diary. So they bring Rodney in, and at that point they go to this young girl who is now 6 months later. She's been recovering from several surgeries. She has a colostomy bag. She's in the hospital, and they say to her, still as a 7-year-old, I need you to look through this magic door. And behind the magic door is a bad man. And if you don't pick the bad man, he's going to go free. And at that point they show her just 2 pictures. One of Rodney Lincoln and one of her cousin. So she picks Rodney. Fast forward, they do a live lineup, and she picks Rodney again, because now she's seen him twice. And they go to trial. And at his first trial, the jury hangs. So Rodney had an alibi. He was with his, at that time, girlfriend, but now since it's trial, and it's years later, she's already married to someone else. She was with him, they'd had dinner, they'd gone to his mother's house. He'd shown up for work the next day, all of these things. So the jury hears that alibi, they hear this identification, they cannot make a decision. So this time, the court now comes forward with what's called a microscopic, the prosecutor comes forward with what's called a microscopic hair comparison. That's where you take a comparison of a hair found at the crime scene, and you compare it to a hair of a suspect, and you look at it under a microscope. What we know you can say when you look at these 2 things under a microscope is that this hair could not have come from this person, or this hair could have come from this person, but what you cannot say is this hair must have come from this person. And that is what the analyst said in this case. So they said this is a match, and they go forward of the new trial, he gets convicted. Fast forward to 2011, we do DNA testing of the hair. In that case, it's not Rodney's. We find a hair, there was another hair that was never compared that was found on one of the young victims, on the 4-year-old, in her clothing. We DNA test that, it's also not Rodney's. So we go to the court and we say, look, this hair's not his, you need to let him out. And the court says, doesn't matter, this identification is still there. The identification is the linchpin. So then in 2015, the victim, a young woman named Melissa, that 7-year-old, realized she made a mistake. And she came forward and she said, I was manipulated. We got new documents from the Department of Family Services that showed that she had identified other men as the bad man, any man that she came in contact with as the bad man, and that they had then coached her, put her on the stand and asked her to practice identifying Rodney Lincoln. She says she made a mistake, it's not him, she knows she was manipulated, and she wants him to come home. So we go back to court, and we now say, just like Joe Amrine, there's nothing you could use to convict Rodney Lincoln. You couldn't arrest him, there's nothing. And the court then said to us, they wrote this in their opinion, Mr. Lincoln mistakenly assumes that if he is innocent, he is entitled to relief. We have only held that innocence is enough if you are sentenced to death, and Mr. Lincoln was not sentenced to death. And that's where we are today. Mr. Lincoln still waits. This is him. He just celebrated his 73rd birthday. And he waits. And this is the system that we have created. And this is why I always feel particularly honored, honestly, to speak with folks like you who come because you care about things and you want to act and change. This is the system that we have to change. The reality is, folks are caught up in it because we have given them no way out. Right? We say that technicalities are what let people out of prison, but technicalities are what keep people in prison. Mr. Lincoln is innocent. The court has said there is persuasive evidence of his innocence, but he's still sitting there. So these are the things that we work with on a daily basis, and these are the things that we ask you to continue to beat the drum for, to ask your prosecutor. The prosecutor in this case had originally said, Mr. Lincoln will be home by Christmas, when the victim came forward on Thanksgiving Day.
And then when the Attorney General stepped in, the Attorney General said, you don't have any jurisdiction to make this decision, and we're going to fight it. This is the same Attorney General's office who had fought Joe Amrine's release. And at the court, when they were in the Missouri Supreme Court, Judge Stitt asked the Attorney General and said, are you saying if there was new evidence of DNA evidence that Joe Amrine was innocent, we would still have to execute him? And they said, yes, because they've already had their process. So this is the system that we need to change, and this is the system that we work with. And I see that my time is up, and I'm happy to take any questions because it is, it's an incredibly troubling thing that we work in on a daily basis.
I'll come to you with the mic, so be patient with me. I had a second trouble. I saw your name first.
Thank you. Most entertaining and informative. How do you decide what cases to take?
Yes, so it's a long process for us. We get applications first. It's about 12 pages long. The first thing we do when we see an application is see, are they claiming innocence? So unfortunately, there aren't a lot of legal assistance programs in Missouri or in the region, so sometimes people will say things like, I need a sentence modification or things like that, and we close those, we reject those. The next thing we do is we collect all the paperwork, trial transcripts, police reports, and we go through them and we say, if this is what the state used to convict somebody, here's the evidence they used. This is what that person said happened. Now in a hypothetical world, where I have unlimited resources and everything goes my way, can I cut down the state's evidence and or build up this evidence such that a jury would have found differently? Sometimes the answer is no. Sometimes there was DNA testing, for example, that happened that's incredibly persuasive and accurate and reliable, and there's nothing I can do and I close it. Sometimes I need 3 witnesses to recant, and all those witnesses have died. So there's really nothing I can do. Then we close those cases. The next thing, if we keep it, then we now have an investigation plan, right? We've just played this game of what we think needs to happen. And then it goes on the next wait list to be investigated. So then we start knocking on doors, talking to experts, doing the analysis, and seeing what pans out. Sometimes I've proven guilt, and I close it, right? You close the case, don't talk about it, you move on. Or in the case of DNA testing, then the state knows because everyone's getting the testing, and we can say, good job, keep going, and move forward. Sometimes the evidence isn't enough either way. And the hardest cases for me are the ones where, at the time of the trial, you read it. We have a case of a man named Carlos Greathouse, convicted of a murder and a rape, where DNA testing on the rape kit shows it's not him. It's not him. The jury knew that and convicted him anyway. So how do I find something new? Because it has to be new. And so those are the hardest cases. And Mr. Greathouse, he's in his 80s, he's dying now with a brain tumor, so he'll probably never get justice. But the reality is, what can I prove? So if I can prove innocence, then I can take it to court. If not, then I have to close the case.
You mentioned that your organization is actively campaigning to try and change policy. What is the greatest source of pushback you get? Like, what's the rationale for holding people incarcerated after we know for a fact that they're innocent? Where is your pushback coming from?
So the concern, and this is a lawyerly concern for anyone who's a lawyer and here went to law school, is always what we call the floodgates argument. If we open this door, how many other people are going to come marching through? And it's not just going to be your innocent person, it's going to be all these people. So the best example I can give is microscopic hair comparisons, which I talked about in Rodney's case, right, where these 2 hairs were compared. The FBI and the Department of Justice did their own review of the cases that the FBI had looked at. And they found a 95% error rate in the testimony about the conclusions, that people had testified beyond what science would allow you to say. All right? So the Department of Justice is now like, are all of these cases going to be litigated and all of these people going to get out? It's really scary for them. I mean, it's expensive, it's going to clog the justice system. But the reality is no, it's not. Because for many of those people, the vast majority of them, there was other evidence that convicted them. Right? So this is one error, but it's not an innocence issue. So that's always the thing that we get, and finality. So we have a system that believes in finality over fairness. At some point, appeals have to be done. You'll hear that over and over. We can't keep relitigating this over and over and over. And so in the case of Ricky Kidd, who I had up here just a second ago, the prosecutor has never argued he's not innocent. The prosecutor has always argued he's out of time, or he already had a chance to prove it. And so that's what it is. We just don't want to be relitigating this thing. If we give him justice, how many of these other people, whether they're innocent or not, are going to be able to relitigate over and over and over again? So that's the biggest pushback. It's a very lawyerly argument.
Right back here.
Would there be any value to having a constitutional amendment in this state that created a condition where innocence was a justification for relief?
Yeah, or even a statute. So a constitutional amendment or just a statute could say that.
Because it seems, in Missouri, it's very easy, well, I say very, it's one of the few states where citizenry can actively push to amend the Constitution. It seems like this would be almost a no-brainer, getting enough signatures to put it on the ballot. Like, I feel like, regardless of your political stripes, most people would agree that if somebody's innocent, I think they should get relief. Would it be worth the Innocence Project's time to push for a ballot initiative for a constitutional amendment in that regard?
I mean, it's certainly something we have considered in regards, especially after the decision came down to Mr. Lincoln, how are we going to fix it, right? And at that point, we are looking at it. I hadn't thought about it in terms of the direct ballot initiative. I'm happy to talk with people who know more about that than I do. But we certainly, I mean, we need a fix, right? And it's within our hands to do that. Right over here.
Thank you very much. It's extremely informative and inspiring. As voters, you mentioned a few things we might be able to influence. I'm not sure, because I don't understand which of these, the Attorney General, the prosecutor, we want to make sure those are good people at the top. And you also mentioned the need for better funding for public defendants. As voters, can we do anything in those three areas?
Yes, so the Attorney General and the prosecutor, absolutely, right? We directly elect those representatives to us and holding them accountable. One of the things we've been thinking a lot about, we're a nonpartisan organization, we don't nominate candidates and things, but we have been thinking about what are the questions we should be asking people when they're up for an office. And I don't think they get asked, which are things like, do you believe in smart justice reform? What would you do if there was an innocent person in front of you, right? Have you ever made a mistake in a case, and how did you fix it? Because I think that there's this unfortunate system where we work in where people are ashamed to say I made a mistake and then try to fix it. It's like, I made a mistake, now I gotta hide it. But it's a human system, we're all gonna make mistakes. Some of these are out of malice, and most of these cases are not out of malice, they're just out of mistakes, and we just need to fix them. So those are the questions that I would ask. If you had an innocence case come in front of you, that it occurred, when your predecessor or your boss was on the case, how would you handle it? Who looks at it and makes that decision? Because it shouldn't be you, right? Because you're gonna go find your boss to do a terrible thing? Like, no, it should be somebody independent. And so asking people those questions. In terms of funding, I wish I had a better answer. So the ACLU Missouri has sued in Missouri to get better funding. We are alleging that there are constitutional violations and letting people languish without counsel. There are people who are sitting in jail still without counsel, and if they just had counsel, get them out on release. But I think the first step is definitely knowing our prosecutors and knowing our Attorney General and demanding that accountability.
Will you be vetting for us when we go to your project site and see certain prosecutors and
Sorry, will you be vetting them so that we can go to your website and find out which ones that you support, since we might not be in the know in that particular legal area?
So we can't support any particular candidate. We're a nonprofit in that regard. We're not a 501c4, which does that type of work. But we will put those questions there to ask. And there are important things to look at. And I think people can see very clearly the places where we have cases and where someone's willing to work with us and where people aren't.
Hand further up front here, but so maybe it would be okay.
Hi, you just made the comment about it's a lawyerly argument, the floodgates argument, and I'm thinking about all these prosecutors and how they sound like really unethical people. And I want to know, why is that the culture? All of these lawyers go to school together at these elite institutions. Why is the culture a culture of hide our mistakes instead of be ethical?
So that's a great question. And I'm going to back it up and give a few caveats. Some of the first caveats being, while I never as a lawyer worked in a prosecutor's office, I did work in 2 prosecutors' offices. So I can actually talk about great prosecutors as well, and they are there. And the other caveat being, oftentimes I have to allege that trial counsel made a mistake. They didn't do the investigation right. We talked about Missouri being ranked 50th. Defense attorneys also are not willing to fall on their sword. Not all of them, great ones are. I mean, and it should be easy in Missouri to just say, I was overworked, couldn't do it. It's the system's fault. And yet still, I have to to say, like, no, you didn't do this, and they'll fight me on it. So I think it's a human thing, or it might be an American cultural thing. I don't know. I haven't done enough research to know why that is, about why we hide those mistakes. But I think there's also some cognitive remorse of what it must be like to know you made a mistake that put someone away for that long. That's a huge weight to carry with you. And then to say, I'm going to just say this and be okay. Now, there are prosecutors who have said that. Glenn Ford, who was exonerated in Louisiana, the prosecutor came forward and said, I made a mistake, I owe you an apology. Glenn Ford rejected that apology, and he died, I think, 6 months later of cancer that went untreated. Many of these clients have untreated illness because of the prison system that literally treats no one. I've yet to see a cancer survivor in prison, for example. But there are some people who do it out of malice. If we're going to talk about Kansas City, Kansas, I don't know how this could have been happening for 35 years and nobody knew. I don't know how. The victim's mother, Sandra Newsom, when they asked about so the detective, his partner, is now the chief of police in Kansas City, Kansas, and he says, I knew nothing. And her response was, if you could sit next to someone for 35 years and not know about that, then you shouldn't be a detective. And so I think that there is shame that we feel that keeps us out. But I don't know. I'm not a psychologist. I just lots of guesses.
Hi. First of all, thank you for that presentation. It was really accessible with a lot of complicated information. My question is in regards to the Ryan Ferguson case. For those of you who don't know, it's Columbia, Missouri. It was released in 2013 after 11 years, I think. What went right in that case that Ryan Ferguson was able to get justice when so many of these men are not?
Yeah, so Ryan Ferguson and Charles Erickson, who is his co-defendant, who falsely confessed and is our client, to the crime that he commits, murder of Kent Heitholt in Columbia. Well, Ryan had incredible advocates next to him. He had a lawyer, many of you have heard of her probably, Kathleen Zellner, who funded it pro bono, worked on that case, tons of money poured into that case. And he had support systems and family members who were also educated and had those systems. So huge social media presence, huge presence from the family. Ryan Ferguson's father, Bill Ferguson, there's a great documentary about it. I'm going to forget the name right now. You probably know it. But you can watch it. It's on Amazon. And Dreamkiller, that's what it's called. And Bill toured the country in a car that said "Free Ride in Ferguson." Went outside D.C. and was handing out pamphlets. And so there's a lot of attention on it. There was a ton of resources that went into it to be able to investigate, and that's where you had success. Our client has a different issue. Our client was falsely confessed and also took a plea. Those are very difficult to overcome, so it's a more difficult battle.
Last question back here.
I'm just curious about Rodney's case. The party that manipulated the 7-year-old girl, was that the prosecutor's office? And if so, what is their incentive to just get a conviction? It seems like there must be.
So the person who went to her and said the magic door line, and that came out in trial testimony from the detective. The detective told us that's how he presented it. He was a detective for a very long time. He continues to be a detective now and does cold cases. There are a lot of reasons. I think when we look at a Lamont McIntyre case, it's very easy to see why they hid this and covered it up. There's a lot of misconduct. In other cases, I do think people just want to get the bad guy. And cognitive bias is real. And if you think this is the bad guy, you're only going to see the things that show this is the bad guy, and you're going to go for it hard, right? So that's what's also a balance. I genuinely, if we're going to have a philosophical conversation, I genuinely believe people are good, and I genuinely believe people are trying to do the right thing, but we are blinded by what we have. And we ourselves, we think about it a lot in our organizations. When we give out something to an expert, that we aren't cognitively biasing our own expert. And then I talked about cases where I've proven guilt, right? So then I kind of go back and I try to think like, well, there are some cases where I don't know if they're innocent or not, and I prove guilt, and there's some cases where I really believe they were innocent, and then I prove guilt, and I have to be like, where was my bias in there, right? And that's what happens just on both sides, and so we're really trying to unpack that.
All right, one question I have before you wrap up is, how can we help your organization and the work that you do?
Well, thank you. So a couple things. One is if you sign up for a newsletter, go online, do that source of information, and share the information of our clients and their stories. Putting the political pressure really makes a difference. Lamont McIntyre would not be out if people didn't know about it. This is a huge deal. We allege severe misconduct on the part of a lot of players. And if people weren't speaking up and saying, we don't want that anymore, we don't want that in our community, Lamont would still be there. And for those of you who don't know, we were scheduled to have a 7-day evidentiary hearing. On the second day, the prosecutor decided to agree with us and agreed to his release. So he got out that day, which is unusual, incredibly unusual. And now that prosecutor, Mark Dupree, is saying he's going to form a conviction integrity unit to review cases. So that pressure that we're looking and we're talking and we're educated and we know is important. We do political work. In Kansas right now, we're trying to pass a compensation law. So when somebody walks out the door in both Missouri and Kansas as an innocent person, the state gives them nothing. They don't get $1, they don't get an ID. There was a very Kafka-esque issue with trying to get an ID for Lamont McIntyre because Kansas has passed Real ID. And so his birth certificate that he's had from when he was born didn't qualify for Real ID, but he has no other ID to get a new form of birth certificate. So it was this whole like going around in circles. It took many days. But we are saying we should compensate people when we harm them. And so we send out, we ask people to support, call your legislature, do that, sign petitions. And then the other is, always considers we're a nonprofit, we are entirely donation run, and just be educated about it. Speaking of education, I did put some annual reports. There are old ones, they're not yet our new ones, but they're in the back, right next to the petition that everyone should be signing.
Great, thank you so much.